everyone. My name is Rebecca Johnson, and I am Fine Olin and Anderman's Upstate Labor Liaison. And I'm here today with partner Vincent Rosillo to talk about workers' compensation and COVID-19. Hi.
Hi, Rebecca. Thanks for taking the time to discuss this very important situation with me today. During these very special times, we've been getting a lot of phone calls and questions regarding people's rights to workers' compensation with the coronavirus.
Absolutely. And we might as well start off with our main question. If a worker is diagnosed with the coronavirus, can they file for workers' compensation?
Yes, they can file for workers' compensation if they've been diagnosed, as long as they can prove a connection to the workplace. So it could either be an accident or an occupational disease, but it must arise out of and in the course of their employment.
Okay, so could I file a claim if I've been exposed to the coronavirus, but I have not yet been diagnosed?
That's a good question. Generally, you do have to be diagnosed with a condition before you can have a case established before the Workers' Compensation Board. But this situation is so unusual and so unique that even if you've simply been exposed to the coronavirus and you can detail your exposure at work, then yes, you can file it based solely on an exposure. Okay,
so I know you mentioned occupational disease. An example for you here that we have a question on is if a worker worked at a hospital and was in contact with a coronavirus patient, and then they test positive for the coronavirus, would that be considered an occupational disease?
An occupational disease is something that happens over the course of time. You don't have a specific incident that happens. It's different than falling off a ladder or picking up a box. This is something that happens to you over time that arises out of your specific job responsibilities. So if a nurse has been exposed to COVID-19 positive patients throughout the course of days, weeks, or months, but you can't specify the exact date or time of the exposure, then yes, she can file or he can file for an occupational disease under the workers' compensation law.
Okay, understandable. Another example we have is if a telecommunications equipment installer contracts the coronavirus as a result of performing work, is that going to be considered a workplace accident?
So as I've indicated before, an accident is something identifiable. You know it as soon as it happens, generally speaking. So if a worker goes to a customer's house to install some telecommunications equipment and that customer is positive for the COVID-19 and then the worker becomes positive, then yes, they would have what we consider an accident for their one-time exposure to that positive customer, and they can file a claim.
Okay. So if a worker states that they've been tested positive for the coronavirus, is that sufficient enough to file for workers' comp?
Now remember, you have to be able to tie it into your work. So just saying that I've been positive for COVID-19 or the coronavirus would not be sufficient. You have to be able to somehow or other tie it into your work activities. That's why more than ever, it's important that you do keep detailed records of your exposure, when you were exposed, how you were exposed, if there were any witnesses to the exposure, because as time goes on, these facts become forgettable. So if you've written them down contemporaneously with the actual exposure, it will help you in the prosecuting of your case.
So that might tie into my next question. If a worker suspects that they've contracted the coronavirus, what should they do in order to file?
Well, remember, you have 30 days from the date of your exposure, if it's an accident, to notify your employer. In an occupational disease setting, you have 2 years from the day you knew or should have known your condition was work-related to notify your employer. But that's not the end of your requirement. You must also file a claim with the New York State Workers' Compensation Board. And if you've had an accident, you have 2 years from the date of that accident, that exposure, to file with the Workers' Compensation Board. For an occupational disease claim, you have 2 years from the day you knew or should have known it was work-related to file a claim with the Workers' Compensation Board. It is your responsibility to file that form, and certainly if you come to us, we would file that form with the Workers' Compensation Board on your behalf.
Okay, great. So under the workers' comp law, what kind of benefits are workers who are diagnosed with the coronavirus actually entitled to?
Well, probably the biggest benefit is the medical coverage. We don't know the extent of the coronavirus and what it will affect down the road. So it's important to get your case established and protected medically. So if you are covered under the workers' compensation law, you're entitled to lifetime medical care for any injury that arises as a result of that coronavirus. So with the medical coverage, you're covered from day one. There's no waiting period. There's no out-of-pocket expenses, no co-pays, no deductibles, no lifetime cap on the amount of benefits that you're entitled to receive when it comes to medical. So that's probably the biggest benefit. The second benefit is the monetary benefits. If you're unable to work as a result of your condition, you're entitled to 2/3 of your average weekly wage, but there are certain maximums depending upon your date of accident. So you're entitled to weekly money if you can't work, and medical benefits regardless if you're able to work or not.
Okay, good to know. Absolutely. So if someone's not too sure how to go ahead and file for workers' compensation, or if they have questions, what can you tell them? How can you direct them?
Well, I think it's important that they contact people who are knowledgeable about the situation immediately. So before taking any further steps, they can reach us and they could ask us for the proper process on how to file a workers' compensation claim.
Absolutely. All right. Well, that's about all the questions I have today. Any final thoughts regarding workers' compensation and COVID-19?
I just want to state that with regard to an attorney's fee, there's never a fee unless you receive an award. If you don't receive an award, there's no fee, and the amount of the fee is set by the Workers' Compensation Board, and it's usually 10 to 15% of what you receive. So if you have any questions, please feel free to call us at 1-800-522-9001 or reach out to us online at www.foalaw.com. Thank you, Rebecca.
Perfect. Thank you.